Okay, thank you all very much for coming to the California Initiative Review Forum for the November 2012 election. I have put the exact date of voting up there. Please remember, November 6th, you need to go vote. We have a lot of initiatives to cover tonight, so we're going to go very briefly through each of the initiatives to give a little synopsis of each one, to tell you what the initiative does, and we will try to get through all of them and then take questions. So please write down your questions as you think of them for each initiative. We do have two publications that you should have received when you came in. One is the full reports, the full analyses of each of the ballot initiatives that will be on the statewide ballot initiative. That's your California Initiative Review. We also have the California Initiative Review initiatives at a glance. These are handy little one-page summaries of each of the initiatives that tell you the current law, the changes that would be made, and a little bit of the pro and con side for each of the initiatives. These are handy also to take notes on as we go through the initiatives, if you jot something down, and we'll try to have time at the end of the forum to take questions. I know that a number of students in the class need to leave for classes, so people will be coming in and out because we still have regular law school classes this evening. So I want to introduce first myself and then my class, and I'm going to let them get right to it. My name is Professor Mary Beth Moylan. I teach the California Initiative Seminar, and I teach the class every time we have a statewide election. And the class always produces the California Initiative Review, and we view this as a public service. We hope that you will come away a bit more prepared to vote on these initiatives than when you walked into the room. I tell my students, and this is my class this year. Say hello, class. Hello. Hello, class. Okay, this is my class this year. I tell my students in the initiative seminar that through the course of the semester, through the course of studying in depth one of the ballot initiatives and hearing about what the other students are researching, they will be the most informed voters in California on the initiatives. And so I think they are, and now you can look at them, the most informed voters of California. Good job. So we're going to actually start tonight. Normally I would go in chronological order, numerical order, but because there are a couple of initiatives that, well, because there are a few students who have to leave for class who will be presenting, that's number one, but also because I wanted to start with Proposition 40. It is the only referendum on the ballot this time around, and the students who wrote the report on Proposition 40 are going to tell you a little bit about the difference between an initiative and referendum and why it makes a difference in this case. So I'm going to turn it over to my students and sit back and enjoy. Okay. First up, Prop 40.
Can you all hear me pretty well? Okay. Thank you for that introduction, Professor Moylan, and good evening, everyone. My name is Kyle Levy, and this is my partner,
Hannah Belknap.
And we're doing Proposition 40. And it's actually nice that we get to go first tonight because Proposition 40, like Professor Moylan said, is a referendum, which actually means it's not like any of the other initiatives that you're going to be looking at on the ballot on November 6th. And let me explain the difference there because it's crucial to understand if you want to understand Proposition 40. All propositions are yes or no questions, and normally that question is, should we create this new program, yes or no? Should we raise taxes, yes or no? That sort of thing. With a referendum, it's still a yes or no question, but that question is, should we keep this existing law, yes or no? So for a referendum, a yes vote is a yes to yes, we should keep this existing law. So if you vote yes on a referendum, nothing changes. It's just a vote for the status quo. If you vote no on a referendum, that means you want to reject an existing law, and that triggers some sort of alternative scheme. And so that's a really important difference to understand with referendums and for Proposition 40. Yes and no votes don't mean the same thing as they do on all the other propositions. Enough about referendums. Specifically, you're here for Proposition 40, which has to do with state Senate districts and our redistricting process. Just quickly, a little bit of history. Every 10 years after the federal census, the state has to draw new legislative districts. That means new state assembly districts, new state senate districts, new congressional districts to deal with population changes, that sort of thing. Before 2010, so before the 2010 census, the state legislature drew all those districts themselves, which creates an obvious conflict of interest because the state legislature is drawing districts that they themselves will then run for and get elected to. So in 2008, the voters decided to change that by passing Proposition 11, which created an independent Citizens Redistricting Commission to handle the redistricting responsibilities. It's a commission comprised of 14 members, chosen through a rather complicated selection process, which I won't get into here. But 5 members of the commission were Democrats, 5 were Republicans, 4 were associated with neither party, and they were required to draw districts that were as geographically compact and as equal in population as possible and as devoid of partisan influences to the full extent possible. And in August of 2011, the Redistricting Commission approved new state Senate, Assembly, congressional districts that met those criteria. The authors of Proposition 40 weren't satisfied with the state Senate district boundaries, so they decided to get Proposition 40 put on the ballot in order to prevent those districts from being used in the November 2012 election, to get voters to reject those districts. And so they put the proposition on the ballot with the hope of having a challenge taken to the California Supreme Court to decide whether we would use these new state Senate districts in this November 2012 election. And the state Supreme Court heard the case and decided, looking at legal precedents, that regardless of whether Proposition 40 passes or fails, we're going to use the Commission's maps for the November 2012 election. And if Proposition 40 passes, if voters approve of the Commission maps, nothing changes. We go on with our lives with those new maps. If Proposition 40 fails, if voters reject the Commission's maps, then the state Supreme Court will take responsibility for appointing special masters to draw new state Senate district boundaries. And I'll turn it over to Hannah for some of the effects of that decision.
Okay, so when the Supreme Court ruled on this, it basically took the reason that the Republican Party put this on the ballot away from them, because the district maps aren't going to be used as they are now. So the parties, which is mainly the Republican Party who was supporting this, dropped out. So now it's a dead ballot measure or proposition, and it has no official support, which means that nobody really cares which way it goes. But that doesn't mean that it doesn't matter how you vote, which is, there's a few impacts. The main one is that if we vote yes, meaning that there's no change on the law, there's a zero cost to the state. If we vote no, there would be a $1 million cost. So basically, an error, which, okay, this is I'm gonna wanna confuse everybody. But this, if we vote no, which is likely to happen, unless we spread the word, we talked about it in our class, to people about voting no on this, the state, people, sorry, I'm getting really confused, I'm confusing myself. A measure that is last on the ballot often doesn't have as many votes as a measure that is at the beginning, just because people get lazy or people don't follow through all the way to the end. So there's a danger that we as voters are going to vote no because we don't understand or we don't know that a referendum really does what it does, and a yes vote will keep it and a no vote will eliminate it. So it's important that we tell everybody to vote yes, because that is the way that we can keep this our law as it is.
Right, essentially, and Hannah touched on this, the $1 million that would have to be spent if the Senate maps are rejected would be the fees to hire new special masters, the fees to implement new maps. Essentially, because the state's already spent the money to draw these maps, if Proposition 40 passes, there's no additional cost to the state, the money's already been spent. But if it fails and we need to draw new maps, it's going to be a cost of, the Legislative Analyst's Office says, about $1 million to draw new ones. Essentially, since no one actually is asking you to vote yes or no on Proposition 40, except us, or we're asking you to vote yes, it would be $1 million spent for no apparent reason. And I think that about does it for Proposition 40. So.
So 39 is about to go, but as always happens when I don't bring notes, I forgot to say thank you to a few people who I want to make sure to recognize, and that's the 3 editors for this year's California Initiative Review. Tristan Brown, Serenia Jimenez, and Andrew Bariskin were our 3 editors for the review, and they did a wonderful job working with all the students and putting this together. Also, yes, so thanks to you 3. I also want to thank the Capitol Center and the director of the Capitol Center, Leslie Jacobs, who's here tonight for supporting this forum, and also a welcome to our new dean, Jay Moots, who is here as well. So on to Prop 39, but and if you do have questions about Proposition 40, which is the referendum, hang on to them. It is confusing, and we can recover it later. Oh, you guys already did that. They're so quick. Okay, go ahead, Prop 39.
Thank you for coming. My name is Nancy Gass, and my partner is Shara Neff. Prop 39 is the California Clean Energy Jobs Act, and what it essentially does is change the way California taxes multi-state businesses. A multi-state business is a business that operates both inside and outside of California. And multi-state businesses have to apportion their income among the states in which they operate. This proposition would not affect any businesses that operate solely in California. For instance, your local barber shop does not have any sales, generally speaking, outside of California, and consequently wouldn't be affected by this proposition. Under current law, California allows a multi-state business to choose between 2 different formulas on how they apportion their income to California. They're allowed to make this choice on an annual basis, and so what they can do is run their numbers both ways and choose the formula that is going to result in the lowest taxes for them in that current year. The traditional formula, what's called the traditional formula, takes into consideration the payroll that they have within California, in other words, California employees, the property that they utilize within California, and their California sales, and goes through a complicated formula to get to a percentage of income that gets allocated to California. The alternative method is called the single sales formula, and it simply says, take your California sales, divide by your total sales, and that's the percent that you will utilize that will get apportioned to California. Proposition 39 would require that all multi-state businesses use the single sales formula. Instead of looking at payroll, instead of looking at property, they'll just look at the sales in California and allocate their income based on that. The Legislative Analyst's Office estimates that this will increase revenues to the state by about $1 billion a year. And Shara will talk to you about how California intends to utilize that money.
As Nancy said, there's an expected $1 billion a year tax increase. Sorry.
Yeah, we want to make sure you get.
Is that better? Okay. So from 2013 to 2018, if Prop 39 passes, $550 million of that expected $1 billion increase per year will go into the California Clean Energy Job Creation Fund, which is created by this proposition. The fund will be used to retrofit public schools and other public buildings to make them more energy efficient, and will also provide training for clean energy related jobs. The remaining $450 million a year will go into the California General Fund. We don't know how this will affect multi-state businesses in California. There are proponents who say it's going to be a good thing because it's going to encourage multi-state businesses to have more jobs in California. But there are opponents who say it's going to encourage multi-state businesses to take their sales out of California, which could harm the economy. So we don't really know which way it's going to go. As Nancy said, there's only going to be an effect on businesses that operate both in California and in other states, so it would not affect businesses that only operate in state. That's it.
So I know that that was a real quick overview, and I didn't give you a lot of details on tax law. I am happy to answer any questions you might have during our question and answer session at the end of this.
Thank you.
Thank you.
Good evening. Can you guys hear me? My name is Melissa Hasty, and this is my partner, Jamie Crillo, and we're here to talk to you about Proposition 35. This is the human trafficking proposition. Although California has existing laws addressing the crime of human trafficking, Proposition 35 will change current law in an attempt to crack down on the crime. The matter appears as a ballot proposition instead of a bill before the legislature, because the drafters were unable to convince the California legislature that their proposed changes were the way to go. Proposition 35 is a get-tough law that nearly doubles the incarceration time required for human traffickers. It increases the fines a violator may have to pay to up to $1.5 million. Although those fines would continue to go to victim of human trafficking programs, so the money's funneled the same place. It allows for sentencing enhancement, something that the current law does not have. So if the trafficking involves bodily harm, or if the party being convicted is a repeat offender for a human trafficking crime, the prosecutor would be able to tack on additional incarceration time. It would require all persons convicted as a human trafficker, even if the conviction was for a labor trafficking offense, to register as a sex offender. This is in part because the proposition does not contain separate definitions for sex trafficking and labor trafficking. Rather, all are part of a single broader definition of trafficking in persons. Basically, so a party who commits the crime of trafficking in persons is someone we would recognize as guilty of a human trafficking offense. The proposition would also change the evidence code to prohibit a defendant from introducing any evidence of the victim's prior sexual conduct if the experiences occurred during the time that they were a victim of human trafficking. It would also require all law enforcement officers to undergo mandatory human trafficking training. This training is already in existence, and many law enforcement officers do partake in the training, but the proposition would make that training mandatory. The proposition would also require all current and future registered sex offenders, not just those registering because they are offenders under human trafficking laws, but all registered sex offenders, to surrender to local law enforcement agencies their internet identifiers. An internet identifier would be their email addresses, screen names, or social networking account information. Proposition 35 also, as I mentioned, expands the traditional definition of human trafficking to trafficking in persons. This expanded definition includes those who would profit from a sex act. Opponents worry that this expanded definition could be interpreted to make voluntary prostitution part of the crime of human trafficking. An example of this would be a child whose mother is voluntarily a prostitute, and using the money that she made as a prostitute, she sends that child to college. That child would then be guilty of the crime of human trafficking because he was profiting by an education from his mother's sex act. While it's really unlikely that a prosecutor would actually charge someone of that crime, it could be leverage if the mother is arrested to coerce her into something. So it's something to keep in mind of the unintended consequences that may come about as a result of this proposition. Jamie's going to discuss additional unintended consequences that may arise in the form of several possible lawsuits.
Okay, so there are several constitutional issues that can be raised with Proposition 35, the first being freedom of speech. The First Amendment of the Constitution says that Congress shall make no law abridging one's freedom of speech. And opponents of Proposition 35 say the new registration laws for sex offenders restrict their anonymous free speech. Although anonymous free speech is not explicitly covered under the First Amendment, there have been several Supreme Court cases that address this topic. In 1960, the Supreme Court stated that anonymous free speech protects unpopular individuals from retaliation at the hand of an intolerant society. There is a 2006 federal law which requires sex offenders to register their online screen names with authorities. So Proposition 35 is California's attempt to comply with that federal law. However, a First Amendment claim may arise if California takes that federal law too far. There have been lawsuits in 2 states, Utah and Georgia, regarding similar propositions, and the courts there have held that no passwords can be received, and they have also held that this information from the sex offenders can only be used when investigating sex crimes. So it will all depend on how far California takes the proposition. Proponents argue that child predators use the internet to find their victims, and so this restriction is appropriate. On the other hand, opponents say that there are certain rights and freedoms that everyone is born with, including the First Amendment, and therefore it cannot be restricted. A second constitutional issue that Melissa touched on was kind of unconstitutional vagueness, that the language is too overbroad. There's cases where offenders may be charged with human trafficking, although their crime had nothing to do with what we would think of as trafficking. The definition of human trafficking gives police officers extraordinary latitude in who to arrest, and it will give district attorneys wide discretion in who to prosecute. So as you can see, Proposition 35 does raise several constitutional issues. A yes vote would support these aggressive, yet untested on the state level, changes in California human trafficking laws, while a no vote would leave the laws as they are.
Thank you.
Hi, I've done a report, so it's a kind of companion piece. It's in your larger publication. It's a companion piece to the Proposition 34 for death penalty repeal. So my name is Grace Utila, by the way, and the report is a national look at death penalty repeal across the entire United States. My main thrust of my argument is that death penalty repeal is kind of gaining momentum throughout the United States, and there's actually been an increase in the rate of change for death penalty abolition. And my thesis is based on looking at a legal analysis of Supreme Court cases on the death penalty, also state court cases and state legislatures passing death penalty repeal bills and bringing it the legislation through the Congress system within the states. So the Supreme Court has been creating new categorical bars for the death penalty. This means that the death penalty cannot be used for certain groups of people, people like juveniles, mentally retarded, pregnant women, insane persons, and so these people cannot be given the death penalty. Also, the Supreme Court has ruled on proportionality. So this means that giving the death penalty for a non-death related crime. So the Supreme Court did rule in Coker v. Georgia whether a rapist could be given the death penalty. They ruled that he could not because it had proportionality issues, because it was not a death did not result from the crime. So this really brought into question proportionality of giving the death penalty for non-death related offenses. So since that decision, there has been no state that has given the death penalty for a non-death related offense. Furthermore, in the 21st century, the Supreme Court, looking at death penalty cases that have come before them, they have been looking more at international opinions, and it's quite significant because they hadn't done this previously. Also, the international viewpoints tend to lead towards abolishing the death penalty. For example, of the 140 nations recognized by the UN, over two-thirds of those actually either abolish the death penalty in law or in practice. So that means they haven't given anyone the death penalty for over 10 years. Also, going along with this changes in the 21st century, although there's only 17 states that have abolished the death penalty as of right now, 7 of those states have done so within the last 21st century. So that's over a third of those states that have done so. This year alone, for example, we have 12 states that have considered repealing the death penalty throughout the country. That includes Connecticut, which repealed the death penalty in April, and including California, which is bringing up the death penalty repeal issue on Proposition 34, which will follow this report. So this is what it would be a very significant deal if California decided to abolish the death penalty, because it would also be the first time that it was done through the initiative process. The initiative process is considered one of the most direct forms of democracy in our country. So it's really considered the people's voice. So it would really be a big deal and the first time that that's happened. I hope you enjoy my report. Thank you.
Good evening, I'm Teal Erickson.
And I'm Jason Richards.
And our summary is on Proposition 34. It's an initiative statute to repeal the death penalty in California. Now, as Grace just told you, we have a long history of death penalty challenges in the United States in general. In California, we've gone through many challenges to the death penalty. The Supreme Court of California has overturned it previously, and the voters have reinstated it. In the 70s that happened. Notably, in the 90s, it was constitutionally challenged based on the method of execution, because California used the gas chamber, or death by asphyxiation. The Supreme Court ended up ruling on that asphyxiation is constitutional under cruel and unusual punishment, so long as the condemned also has a choice for preferring lethal injection. And so we figure as long as the condemned chooses asphyxiation, that it's constitutional and not cruel and unusual. The current state of the death penalty in California, there is actually a de facto moratorium. It was caused in 2006 by a district court judge, a federal court judge in California, saying that the California's method of lethal injection is unconstitutional because it employs a 3-drug cocktail to execute. The importance of that is that one of the 3 drugs is a paralytic, which raises the question of whether somebody is actually experiencing pain while we're waiting for them to pass away because they are paralyzed. The state of California last year brought a new proposal to the state, and the judge ruled it's still unconstitutional because it still used a 3-drug cocktail. So currently, we are not executing anyone. We haven't since 2006, and there are no plans to fix this in the near future.
Okay, so basically, now what you want to know is what the Prop 34 actually does in relation to what we have now and then what would change. The first thing Prop 34 does is it would end the death penalty in California. What this means is that everybody who has already received the death penalty and is on death row would then have their sentence changed to life in prison without the possibility of parole. And that would apply retroactively and to all new cases that come in. Secondly, everybody convicted of murder, just murder, all the other convictions would stay the same, but murderers that are convicted would be required to work while in prison, and then the wages that they make would be applied to victim restitution funds. In other words, it would go to families of the victims or to some fund that would go for that purpose in a general sense. And lastly, we would create a new fund called the Safe California Fund. It's a $100 million fund. It would be taken from California's general fund. And this new fund would go towards law enforcement in enforcing rape and murder cases. The reason for this is that rape and murder cases in California remain vastly unsolved. For some reason, we just haven't been able to solve a lot of them. They figure, okay, we're going to put some more funding into it. Maybe that'll help. So it would be specifically earmarked just for law enforcement to work on rape and murder cases. And since we're talking about money, we should probably talk about the fiscal impact of Prop 34. It would save the state, they estimate, between $100 million a year and $130 million a year. The reason for this is that the way things currently stand, you have a lengthy appeals process when someone is convicted and put on death row with the death penalty. They want to give convicted parties as many chances as possible to exhaust all their appeals before they're finally put to death. There's over 700 people currently on death row, and we've executed, what was it, 13
since the 70s.
Since the 70s. So we really don't execute people that often. And then the other reason, well, there's multiple reasons. Mm-hmm. One other reason is that in the conviction process itself, when you have a death penalty trial, you go to a death penalty phase of the trial. If the death penalty's gone, you no longer have that phase, and so it cuts out a huge phase of the trial anyway. Mm-hmm. Any other reasons you can think of?
And also the cost of maintaining death row is far greater than just maintaining regular prisoners in the general population, based on increased security and mostly increased security, but also increased doctor's visits, things like that. It's much more expensive to maintain death row.
Okay, so just to recap, no more death penalty in California. Murderers have to work while in prison, and the money goes to victims restitution fund. And we have a new fund created, the Safe California Fund, that goes for rape and murder law enforcement.
And one more note on number 2, the second point, that is requiring murderers to work is already an option for a court to put on a condemned prisoner, and it's usually exercised, but this specifically would codify it. So there probably wouldn't be a big change with that. So just to clarify, on this statute, on Prop 34, a yes vote would actually be saying no to the death penalty, and a no vote would be supporting the death penalty.
Yes.
So, thank you.
Thank you.
I also did a report. Mine was on some of the early history of the initiative process and where we were as a state in the country as we started passing this initiative process, giving people the power to pass laws without the legislature, and what some of the lessons are from that time period that we can apply to today. In 1911, California became the 10th state to pass an initiative process for the voters. This brought direct democracy to California. As most of you know, the United States isn't really a democracy, we're a republic. We elect representatives to represent us in Congress, pass laws, and run the government as we say they should as their electors. But the direct democracy initiative process gives the voters the right to pass laws without help or interference from the legislature. This was particularly important because after the Civil War, towards the end of the 19th century into the 20th century, most of California and the country was run by really a group of aristocrats, robber barons, railroad owners, the very wealthy, who controlled most of the government, most of the means of transportation. Particularly in California, corruption was rampant. Bribery was the way that things got done in government. Politicians were known publicly to be in the pockets of different railroad companies. So this sort of sparked a political movement based largely on agriculture. Farmers were being put out by larger farming collectives, so they started groups with suffragettes, prohibitionists, people who just want smaller government, people who want larger government, people who were against monopolists, flat taxers. It was a wide range of group, everyone who decided they wanted some form of direct democracy in California. The first version of direct democracy in the United States passed in South Dakota in 1898. Many states followed suit. Today we have 26 states and the District of Columbia with initiative process in one form or another. Some allow initiatives, some of them only allow referendums, some of them have restrictions as to whether constitutional amendments can go before the people, but they all have some form of it. So at the beginning of the 20th century, the progressive movement was in full swing. All these groups that started to get political, electing politicians who were either sympathetic or came out and instead they were against the railroads or they were populist in some form or another. Hiram Johnson was elected governor largely on this platform, progressive and anti-railroad. And so when Hiram Johnson won the governor's mansion and other progressives won Congress, they passed the 1911 California constitutional amendment giving direct democracy to the people. So some of the reasons behind this and what some of the guiding principles were is that they want to preserve the power of passing laws for the people as it was intended originally. They didn't want special interests or corporate interests to be able to push through whatever piecemeal legislations that benefited them through Congress, through bribery or other forms of corruption. So this direct democracy process protects the power of the people against corporate interests and special interests, but also gives them the tools to combat corruption. If you know that the people have the power to pass laws by themselves, they felt it would be a way of cutting down on corrupt politicians. They wouldn't be as beholden to corporate interests because they knew that the people had a way of passing laws themselves or rejecting laws themselves. What we have today, and it's sort of developed over time throughout the 20th century as initiatives became more and more popular, and this particularly started Prop 13, that the same special interest groups and corporate interest groups got wind that the initiatives were a really good way to pass laws that they also liked. So what you end up getting is a lot of complex initiative being put on the ballot, initiatives that are written in a way to confuse the voters or to hide key facts. You get large ad campaigns. You've all seen them on TV for various propositions for or against, much of which is funded by groups with a specific interest in that prop. So you're going to hear about Prop 37, I believe, next, which involves labeling genetically modified foods. On one side, you have the organic food industry that wants genetically modified foods to be labeled. On the other side, you have companies like DuPont, Monsanto, and Pepsi, who have a vested interest in making sure that their foods, which are genetically modified, aren't labeled. Props 30 and 38, which I'll hear about in a little bit, involving funding education. The issue becomes, well, how are we going to fund it? Do we like this plan, or do we like this other plan that increases taxes or it cuts costs? How are we funding the various interests that we have, and how do we know which side we're on, that various groups are funding on either side? So I think one of the important things, and I think the reason most of you are here, is that the easiest way to combat this is an informed voter, knowing what the propositions are, knowing who's funding what side, knowing what they actually say is important. It's probably a boring answer, one that most of us know, but that's kind of the only one that we have so far. So there's more of it in my report. Hope you enjoy.
Good evening. My name is Vincent Maja, and this is Jessica Pham. And we're here to talk to you about Proposition 37, the California Right to Know Genetically Engineered Food Act. Prop 37 basically seeks to achieve two things. The first is to get any food that has any ingredients that have been genetically modified to be labeled as such. And it also seeks to stop the use of the label of naturally made or natural and any foods that have been processed in any way. Now, genetically modified foods are defined as any food that has been genetically manipulated, whether it be direct manipulation of the DNA, artificial insertion via virus, or simply taking out pieces of the gene code. But older techniques like selective breeding, like how we got our tomatoes to be big in the first place, are still acceptable. The reason why the proponents of this proposition want to get genetically modified foods labeled is because there have been no real long-term studies as to the potential cumulative effects of using genetically modified organisms. For example, Monsanto has come out with a lot of crops that are bred to be resistant to Roundup, which means that they secrete proteins that make them resistant to the herbicide so we can use more herbicide. Well, we don't necessarily know what might happen by ingesting all these things over time, and we also increase the use of pesticides, which can potentially adversely impact the environment. The measure looks to do this by requiring manufacturers of GE foods to either label it on the packaging as made with genetically engineered materials, or in the case of raw agricultural products, to have the bins in which your potatoes, say, are found in the supermarket to be labeled with the with potentially grown with genetically modified organisms. In addition, any foods that are processed, and the proposition defines processed as as one of the myriad measures such as freezing, canning, drying, to be prohibited from using the term natural or naturally made, because the proponents feel that this might mislead people into eating foods that may or may not actually be naturally made. Any infraction of either the GE labeling portion or the natural food labeling portion would be considered misbranding. And that would be grounds for the agency enforcing the measure, which would be the California Department of Health, to come in and potentially fine the manufacturers anywhere up and down the chain from the grower to the retailer. And it also would allow any private citizen who notices that something is mislabeled to file an injunctive suit, a lawsuit, to have a court stop the manufacturer or the labeler from using one of the labels, or force them to start using the label. For example, if someone was selling potatoes that were genetically modified but were not labeled, they could have them label it. One of the other things with Prop 37 is that there are a lot of exemptions written into it. These include alcoholic beverages, any products, food products that are derived entirely from animals, such as meats and eggs, and all dairy products. So this could result in a strangely paradoxical scenario where the same set of grapes that are grown can be pressed for grape juice and be required to be labeled. But if you fermented them and sold them as wine, they wouldn't have to be labeled. So Prop 37 has a lot of hands in it. And to speak about the impact is Jessica.
Okay, so it sounds like a very straightforward bill. And I know a lot of our primary concern is, what are the costs? How much will Prop 37 cost the state? How much will it cost the food manufacturers? And more importantly, how much will it cost to us as consumers? So the proponents of Prop 37 and the opponents both agree that this measure would result in an increase in state administrative costs. The Department of Public Health would be held responsible for promulgating and enforcing these regulations. They would incur additional costs to review the documents and perform periodic inspections to ensure that food manufacturers and food companies are actually complying with the GMO labeling requirements. And depending on the methods and extent to which the department chooses to enforce these regulations, these annual state costs could range from a few $100,000 to over $1 million. There's also a potential cost to state and counties due to litigation resulting from violations of the GMO labeling laws. Opponents of Prop 37 fear that this initiative will invite frivolous lawsuits, since private citizens can sue family farmers, food manufacturers, almost anybody without establishing any specific damage or harm. The extent of these costs, well, this in turn would increase the number of cases filed in state courts, but the extent of these costs would be contingent on the number of cases filed, the number of cases that are prosecuted by the state and local governments, and then the decision-making process that the court uses. However, the involved parties' required legal fees would support some of these increased court costs. The parties in each legal case, for example, would be held responsible to pay the court filing fees under existing law. And in the context of overall court spending, proponents argue that these costs are likely to be insignificant in the long run. Next, I'm going to talk about the effects that Prop 37 will have on the food producers and on consumers. Proponents argue that this initiative will have no cost impact to food producers and to consumers because food producers constantly revise their labeling, and they already include nutritional and calorie information on these labels. So how much more can the statement that says this food product was produced through genetic engineering, how much more cost can happen by adding this one statement? Proponents also argue that the cost of relabeling decreases as the length of the compliance period increases, because food manufacturers, like I said, they redesign labels periodically. For instance, the FDA has estimated that 3/4 of package labels are normally scheduled to be changed during any 30-month period. And Proposition 37 here provides for a 20-month compliance period. You have until November 2012 until July 2014. Manufacturers have this 20-month compliance period to include the necessary GMO labeling information. And so as a result, labels can be redesigned to reflect new regulations at a very insignificant cost. Conversely, opponents of Prop 37 believe that this initiative, however, will have a very devastating effect on the food production industry and on consumers as well, because based on the studies that they relied on and cited to, they relied on these case scenarios that said that if Prop 37 was passed, food manufacturers would feel compelled to replace their genetically engineered ingredients for organic or non-GE counterparts. However, that is not the case. Prop 37 only requires labeling. There is no substitution requirement, and opponents have agreed that if food manufacturers decide to just label and not substitute their GE ingredients, there will be no cost impact to the consumers and to the food producers as well. So I just want to remind you all that Prop 37 does not ban GE foods. It is merely a labeling law.
Good evening, my name is RJ Cooper and I'm going to be presenting Prop 36 today. That is the Three Strikes Reform Act. Quick overview on what Three Strikes does and where it came from for those of you who aren't intimately familiar with its origins. It passed as a voter initiative in 1994. Mike Reynolds was kind of the person who spearheaded the movement. His daughter was murdered by a repeat felon. And then in 93, some of you might remember Polly Klaus. She was a 12-year-old. She was kidnapped from a slumber party, and when they found her body, support for Three Strikes sort of went through the roof, and that's what pushed the initiative to pass in 94. And what Three Strikes does today is essentially it classifies certain felonies as serious or violent. And you can see a list of those at footnote 850 in your book if you're curious, but I mean, these are things that you'd expect: murder, rape, arson, kidnapping, assault with a deadly weapon. If you commit 2 of those type of felonies, then your third felony, regardless of whether it is serious or violent, will get you a life sentence and you will not have the possibility of parole for 25 years. It's been called the nation's toughest resentencing law for repeat offenders. And since it's passed, crime in California has dropped steadily each year, even as the population has increased. Three Strikes proponents claim that it saved 10,000 lives and $54 billion in prevented crime. But it's worth noting that crime also dropped in places like New York that did not have Three Strikes during the same time period. So while there is a temporal link to the drop in crime, it's not necessarily a causal link. They tried to reform Three Strikes in 2004 through Prop 66. Essentially, that would have required that your third strike be serious or violent. It also would have reclassified some of the felonies. That proposition failed. So in its wake, we have Prop 36, which was written and spearheaded by the Stanford Three Strikes Project, the Stanford School of Law. It's a little more modest reform, essentially. It does not try to reclassify any felonies, and it has some exceptions to the rule. But essentially what Prop 36 will do is require that your third strike be a serious or violent felony to receive a life sentence. That's it in a nutshell. And it has a prospective prong to it, and then a retroactive one as well. So prospectively going forward, your third strike has to be violent or serious. And then for those that are already sitting in prison with a life sentence right now, for a non-violent, non-serious third strike, they can petition a judge to have their sentence reduced to essentially double the usual sentence. If the judge finds that they don't pose a serious threat to society, once they serve that double sentence, they can be released. A couple of the exceptions of Prop 36, if you have a conviction for rape, child molestation, or murder, Prop 36 will not apply to you, and 3 strikes as it's presently construed will still apply. So, and then also if your third offense requires you to register as a sex offender, if you were dealing cocaine or heroin, if you intended to inflict bodily injury on another person, then Prop 36 will not apply. So as far as cost savings, the Legislative Analysis Office estimates that Prop 36 will save $70 million a year annually in California, but the office admits that that number could fluctuate up or down because it's just really hard to tell how many people will be released and how many people will commit future crimes. Prop 36 proponents say it'll be $100 million of savings, and the opponents say there will be no savings because essentially the theory behind Prop 30 or 3 strikes law is that you have serious criminals, a small number of them, who just commit crimes over and over and over again, and they cannot be deterred. So opponents of Prop 36 will say, hey, once you let these people out, you're just going to commit crimes again, and not only do we have to pay for those crimes, you're going to have to incarcerate them again anyway, so there'll be a negative savings. And that's essentially Prop 36 in a nutshell. Thank you.
Good evening. My name is Alicia Heilman, and my partner here is Rebecca House. We worked on Proposition 38. Proposition 38 is the tax for education and early childhood programs. As educational funding currently stands in California, how much goes to education is defined by a proposition earlier passed known as Proposition 98. Proposition 98 takes a portion of the general fund and says every year that portion has to go to funding education. And there's a couple different formulas. It based on how much should go to education, and it really depends on if the California economy is growing or shrinking or how the economy is doing as a whole. This year and last year, California education received approximately 40% of the general fund, and from all funding sources it received $68 million. This is to fund 6 million students who are currently enrolled in California public schools. In addition to that, California currently stands as number 47th in the nation in per pupil spending, and California has the largest class size. Proposition 38 works to change the amount of funding California receives, and all funds received from Proposition 38 will go only to education. Essentially what Proposition 38 does is it increases taxes on a sliding scale. Based on the sliding scale, people making the least amount of money, which is less than $7,316, will receive no increase in their taxes. People making close to $7,316 will receive about a 0.4% increase in the taxes. On the other end of the scale, people making more than $2.5 million will receive about a 2% increase on their income taxes. All of this money that is raised will go to the California Educational Trust Fund, and it will be designated solely to going to schools. And this tax increase will be good for 12 years. Approximately 60% of this money will go towards funding education in grades K through 12. 10% will go to funding early childhood education, and 30% will go to funding educational state debt. And Rebecca's going to talk a little bit about some of the strings put on that money.
So the actual goal of the proposition itself was to send money directly to the school districts that would use it then to fund the education of students, so that the money would go more to students and not to Sacramento. So to effectuate this goal, the writers put some strings on the money that went to the districts. First of all, the budgets of every district have to be published. They have to be published online, and they have to be publicly accessible. Second, the school districts have to provide open public forums where people in the community can come give their input on how the money should be spent in their district, and also give input on whether or not they think the districts are making good use of the money that gets sent there. Second, a specific amount of money will be spent directly on increasing technology in schools and also increasing teachers' education so that they can teach students about technology. And finally, a preschool education program will be funded through this initiative process. As you might already know, there's a conflicting education ballot initiative that you also get to vote on this election term, which is Proposition 30. You'll actually hear about Proposition 30 in detail in a little bit, but we wanted to also touch on what happens if both of these initiatives pass. So if both Proposition 38 and Proposition 30 pass in the election, the Constitution of California dictates that whichever one had the most yes votes will become the law. So even if Proposition 38 wins, it still has to be win with more yes votes than Proposition 30. That's it for us. Thank you.
Again, thank you all for being here this evening. My name is Andrew Launderham, and this is my partner, Nicholas Poper. Nicholas and I will be presenting on Proposition 30, the Schools and Local Public Safety Protection Act of 2012. This is a constitutional amendment proposed by our current governor, Jerry Brown, and it was an effort to raise approximately $6 billion for education. And tonight, there are a few key provisions that we would like to present to you. First off, Proposition 30 raises the personal income tax for 7 years. If passed, Proposition 30 would add 3 new tax brackets to California's existing personal income tax scheme. The current maximum rate for individuals is 9.3%. And under Proposition 30, the California filers falling in the 3 new brackets, as you can see on the screen and I believe in your handouts as well, they would have their taxes increased by 1%, 2%, and 3%, respectively creating personal income taxes of 10.3%, 11.3%, and 12.3%. And you can, I won't explain it, but you can look in the chart here and the chart that is provided for you to see how it affects single filers, head of household filers, and joint filers. Additionally, if Proposition 30 is passed, there will be an increase to the state sales tax. The increase would be 0.25%, and to put it in perspective, the current state sales tax is at 7.25%, and with additional county and city taxes and additions, the state average is roughly 8%, a little over 8%. So it would go from a state sales tax increase to approximately 8.25%. And it is important to remember how these two taxes will, the tax increases will affect Californians. And the personal income tax is estimated to affect the top 1% of personal income taxpayers in California, and the state sales tax increase would affect all Californians making purchases within the state. Now, what happens with this money is that this money is predicted to generate approximately $6 billion per year. And this money would be put into a education fund. And this education fund is mandated by Proposition 30 to be distributed 89% to K through 12 schools and 11% to community colleges. For the second important piece, of Proposition 30. In 2011, the state transferred the responsibility of administering approximately $6.3 billion worth of funds to local governments in what was called the 2011 realignment legislation. Now, the $6.3 billion isn't new funds. It was pre-existing funds from the California's General Fund that currently they fund programs managing incarcerated adult offenders, programs that manage or supervise parolees, and additionally treat substance abusers. However, currently there is no guarantee that these funds will continue to be transferred from the state's responsibility to these local governments. However, if Proposition 30 were to pass, it would guarantee that this $6.3 billion would continue to go to local governments. And I'll now pass the microphone on to Nicholas.
So for the last point, I want to talk about the effect on the budget for this year. Currently, when the state passed the 2012-2013 budget, they assumed that Proposition 30 was going to pass. What this means is that if Proposition 30 fails, there'll be a $6 billion gap in the budget. The way that they deal with this is called a trigger cut. Basically, $6 billion will be automatically cut from the budget, and most of that will come from public education. This is the emphasis why Prop 30 has on education, because if it doesn't pass, then mostly all of the cuts will come from public schools, K through 12 plus city colleges. So just to sum up everything for us, yes vote would temporarily raise personal income taxes and state sales taxes to generate money for public schools, and it would also ensure existing tax revenues would continue to be managed for local governments' public safety. A no vote would mean that taxes remain the same. It would also mean that there would be a state spending would have to be reduced by $6 billion. And third, that the $6 billion of locally managed money that's given from the state will go back to the state. Yep, thank you.
Good evening. My name is Robin Miller, and I am here to talk to you about a report I did on how ballot order was determined, specifically for Prop 30 and Prop 38 that you've heard about. Because as you just heard, Prop 30 was two tax increase initiatives, Prop 30 and 38, with 30 being sponsored by our Governor Jerry Brown, and 38 by a civil rights attorney by the name of Molly Munger, both California Democrats. Historically, California statutes govern how ballots are placed, how the ballot placement order is determined. Specifically, our election code provides that initiative measures are to be placed on the ballot in the order in which they qualify. However, on June 27th of this year, Governor Brown approved AB 1499, which was an amendment to a budget trailer bill that moved bond measures and constitutional amendments to the top of voting ballots. According to AB 1499, Governor Brown's tax increase initiative, Prop 30, as we know it now, would receive prominent placement on the November ballot because it's a constitutional amendment, whereas the rival tax increase proposal by Molly Munger would not receive prominent placement on the ballot because it's an initiative statute. On June 28th, one day after the passage of AB 1499, Molly Munger filed a lawsuit to block the new state law from taking effect. The lawsuit alleged that Munger's proposal should have been given higher placement on the ballot because first, her campaign submitted signatures ahead of Governor Brown. Second, it had fewer signatures to count because it's an initiative statute and not a constitutional initiative. And third, Munger also argued that Democrats in the legislature acted illegally in changing state election law by qualifying AB 1499 as a budget bill in an effort to move Governor Brown's tax increase initiative to the top of the ballot. In response to Munger's allegation, you two may be asking, how did AB 1499 qualify as a budget bill? To qualify AB 1499 as a budget bill, lawmakers inserted a $1,000 appropriation for the Secretary of State for implementation, claiming that it will cost $1,000 to move 11 numbers around on a sheet of paper and post it on the Secretary of State's website. You may then also be wondering, how does a budget bill factor into ballot order? In 2010, California was suffering major budget gridlock, and voters passed Prop 25. Prop 25 was to reduce the legislative vote requirement for a budget from 2/3 to a simple majority. Proposition 25 also amended the California Constitution to provide that budget bills and other bills providing for appropriations related to the budget may take effect immediately once signed by the governor. So by classifying AB 1499 as a budget bill, two advantages existed. One, it only needed a majority of vote per Proposition 25, and it took effect immediately. If AB 1499 did not relate to the budget, lawmakers would have needed a 2/3 vote to enact it before this November's election. Thus, by using budget legislation, Democrats were able to change the ballot priority in an expedited manner. Therefore, on June 26, lawmakers, using the new powers handed to them under Prop 25, made the passage of AB 1499 as part of this year's budget, which allowed it to take effect immediately. AB 1499 was then approved by the governor on June 27th. Immediately after AB 1499 was passed into law, the statutory provisions of the California Elections Code was amended. Per the amended election code, Governor Brown's tax increase initiative would receive higher placement on the November 12 ballot, whereas Munger's position would fall to the bottom as an initiative measure. Under previous practice, Brown's initiative would likely have appeared 9th rather than 1st. Secretary of State Deborah Bowen said that Governor Brown's initiative was the 9th to qualify and Munger's was the 10th. As I stated earlier, one day after the passage of AB 1499, Munger filed a lawsuit against the Secretary of State in an attempt to block the new state law from taking effect. While Governor Brown did not intervene in the case, he did defend AB 1499 by stating that it deserves the dignity of being ranked with other constitutional measures because it's not a mere statute but a fundamental change in how the state operates. Furthermore, attorneys for the legislature argued in their brief to the court that lawmakers have unique authority to define what counts as a budget bill, and that they followed the state constitution by including the $1,000 appropriation. While the Howard Jarvis Taxpayers Association did not intervene in the initial court proceeding, in response to AB 1499, their president stated that it clearly was not budget related. He went on to further state that he doesn't even think it passed the ha-ha test. It's such an apparent abuse of power. In response to Munger's allegations, attorneys representing the California Secretary of State asserted that Munger's campaign had not proven that there were problems in signature count and verification. Additionally, attorneys for the Secretary of State argued that delaying the numbering of voting initiatives could wreak havoc on the fall election, claiming that various groups seek to get their election number early so they can order their lawn signs and start their campaigns. On July 9th, the lawsuit was brought before the Sacramento Superior Court. The hearing was entirely focused on arguments surrounding election procedures and whether Munger's campaign brought their suit against the state or the county. The issue of whether lawmakers illegally passed 1499 was barely even mentioned. Lawyers for the defense, including one for the legislature, urged Sacramento Superior Court judge to settle the ballot order dispute without weighing in on whether the majority vote bill passed by lawmakers was constitutional. The judge then ruled only on the signature verification process and did not address Munger's allegations. Coincidentally, Munger's attorneys never discussed AB 1499, and Judge Kennedy did not rule on the matter. The judge did rule that California Secretary of State had acted properly in renumbering the ballot order, and Governor Brown's tax proposal would appear at the top. After the July 9th hearing, Munger's campaign announced it would not appeal the ruling and would focus on its campaign moving forward. However, the ruling drew an immediate appeal from the Howard Jarvis Tax Association. On July 9th, Howard Jarvis challenged AB 149 in California's 3rd District Court of Appeals, seeking to invalidate AB 1499 and its status as a bill necessary for implementing the state budget. The appeal contends the bill was not budget related and Democrats misused Prop 25. In response to the appeal, the Court of Appeal issued an order to the Secretary of State asking her to reverse her action in giving Governor Brown's tax initiative preference in the ballot materials or to submit a brief justifying her position by July 30th. In the court response to the appeal, attorneys for the Secretary of State and Governor Brown's tax campaign provided no legal arguments defending the measure. Instead, they presented more logistical difficulties with reordering ballot measures since the initiative numbers were already assigned on July 9th. Attorneys for Governor Brown's tax campaign said rescinding the ballot numbers would disrupt the election process and cause voter confusion. Furthermore, lawyers for the Secretary of State asserted that they had no authority to ignore the laws passed by the legislature. While the Court of Appeal for the 3rd District has yet to issue a ruling on whether or not AB 1499 is in fact a piece of budget legislation under the California Constitution, If the appeal should succeed and AB 1499 is invalidated, it could set precedent beyond the November ballot election by potentially narrowing the type of changes that state leaders can pass on a majority vote. Given all this, you may be wondering, does ballot ordering really even matter? Many election experts believe that fickle voters will lose their interest as their eyes move down the ballot. Thus, appearing higher on the ballot can increase a candidate's or a law's view of passing. Nonetheless, some believe that low level of trust voters already may have in politicians. Governor Brown's passage of AB 1499 is a type of behavior that generates more suspicion among voters. In addition, regardless of where tax increase proposals appear on the ballot, proponents of taxpayers' rights feel given the unpopular reaction by California voters to tax increases in recent years, with the last 8 being rejected, it really does not matter where the measure appears. In conclusion, if Governor Jerry Brown and Molly Munger agree on one thing, it's that California needs to raise taxes to provide more funding for schools. However, this November's election, voters who share that view will have to consider 2 distinctively different approaches to accomplish that goal. Conventional wisdom has that competing measures on a single ballot will only hurt each other, causing voters to reject both or split their votes. However, while ballot order has historically been held to influence voter support, the outcome of Governor Brown's initiative receiving higher ballot placement has yet to be seen. In addition, while the pending validity of AB 1499 is currently being reviewed by the California Court of Appeals, it will not affect the ballot numbering, obviously, in this election, but it may have impact beyond this election. Thus, the effects of Prop 30 and Prop 38 will be realized not only on election night, but also in the California courts after November, as there is speculation that this case could go as far as the California Supreme Court. Thank you.
Howdy, my name is Zachary Hutzel, and I'll be talking to you about some of the origins of the California fiscal crisis and how it relates to Prop 13 passed 38 years ago and Prop 30, which is on the ballot today. See, Prop 13 38 years ago was an initiative measure that severely restricts property taxes and restricts the ability for the legislature to raise taxes by requiring a 2/3 vote in the legislature in both houses. And in many ways, this has had a lot of unintended consequences in California's ability to raise revenue. First off, while the property tax revenue did fall significantly after it was passed by roughly 58%, government spending didn't necessarily fall. Government didn't shrink because voters still needed the services that were provided by government, mainly through the property taxes, which were education, public safety, and transportation. So California is instead a rather unique tax structure, tax revenue structure compared to other states in that it is extremely reliant on income tax, capital gains tax, and sales tax, which are all extremely volatile. They follow the business cycle, so during economic downturns, property tax revenue is smaller than expected, and during economic upturns, it's higher than expected. But one problem with this is that when during an economic upturn and property tax revenue is high, there is a government surplus, and government surplus is probably the least popular thing that the government can have among voters. And through the initiative process, through the boom times, have voted for tax cuts and voted for specific spending measures that have restricted how the money that's already collected can be spent and restricted how much revenue can be collected by the government. And at the same time, the 2/3 restriction on the legislature makes it harder for them to find new avenues of revenue. But what has also happened in the last 30 years is that the initiative process has gained enormous popularity, and that people have found that it is easier, in fact, to do significant tax changes and other legal changes through the initiative process as opposed to the actual legislative process. So what we have now is Prop 30, which is essentially the governor saying that he wishes to completely bypass the legislature and take it straight to the people. And in many ways, this is exactly what Californians have been voting for in the last 38 years. And we'll just have to live with it. Thank you.
Good evening. My name is Erica Scott. I'll be talking about Proposition 33. This is not my report. It was written by Kelly Bowler and Elliot Persh. So if you have any questions at the end, I'll do my best to answer them, but I'm not an expert. All right, so Prop 33 is titled the 2012 Automobile Insurance Discount Act. What it will do is allow insurance companies, when determining the premium that an insured will pay, to use a factor considering how long and how continuously they have been insured in California. Currently, the law says that there are several mandatory rating factors that the insurance companies must consider when determining a premium. They include driving record, the number of miles driven annually, and the number of years of driving experience. So this obviously gives a lower premium to older persons who have a good driving record and who have been driving for a long time. There are other regulations, but there are many small things. So the current law allows persistency of insurance. That means how long and how continuously you've been insured to be an optional factor in determining the rate. But the rate is only good as for how long you have been insured with the insurance company who is giving you the discount. So the persistency is only good if you've been with State Farm for 5 years, then you can get the discount. Or if you've been with another insurance company for that time. What this law would do is allow the optional persistency of coverage to apply to whatever insurance company you go to. So if I am insured at State Farm for a year and then I go to Allstate for a year and then I go to some other place for 3 years, I have 5 years of coverage total and I'm eligible now at whatever insurance company I go to for this persistency discount. Now, the persistency discount is optional, so insurance companies don't have to offer it to people who they're giving premium quotes to, and they can rescind it at any time. So they could offer it for 1 year and then decide they don't want to give that discount anymore. So the consequences of a yes vote are that this persistency factor, whatever insurance company you go to, if you have 5 years of coverage, you'd be eligible for a discount if the insurance company decided to use that, that factor. What it would do, essentially, is give a discount to drivers who have had insurance for 5 years. It also provides the discount to persons who have had a lapse of coverage. So if you have not been insured for 90 days of that 5-year period, you can still be eligible. If you have been uninsured for 18 months of that 5-year period, but that 18 months you were unemployed because of a layoff or a furlough, not unemployed because you were a bad employee, but only for a layoff or a furlough, then you can still get that persistency discount. If you had a lapse in coverage because you were on military duty, you're also still eligible for the discount. It would also include children would be eligible for their parents' persistency discount. It also provides a percentage discount. So if you've been insured for 4 years, you get 80% of the persistency discount, and so on and so on. The yes vote will allow some drivers to potentially get a discount on their premiums. It will not allow for this discount for new drivers or drivers who have not been able to afford insurance for some year or who have not had 5 years of continuous coverage. So if you drive for 5 years and stop and you're not paying insurance, 5 years later you buy insurance again and you start driving again, you don't get this persistency discount. So opponents say that it may increase premiums for persons with a short driving record. New drivers, poor persons will be adversely affected because their premiums will go up. And also, opponents say that since the persistency discount is optional and it can be taken away at any time, even if it is given at first, that insurance companies will sort of seed you with an artificially low premium and then take away the persistency discount and have you pay a higher premium. There's some arguments about increased state tax on the revenue derived from premiums, but it's all very fuzzy. So not really sure what the fiscal impact would be for drivers or for the state in terms of taxes. The main proponents of the proposition are American Agents Alliance, which is a group composed, it seems, of executives of the Mercury General Corporation, which is an insurance corporation, and the chairman of the board of Mercury General Corporation. So you have insurance companies who are promoting the proposition. The proponents say that it will encourage people to maintain coverage. It'll make the roads safer, more people will have insurance. That's all good. And that insurance will be cheaper for persons who have longer insurance records. But because of this continuity of insurance, new drivers, people with lapsed coverage will have higher premiums, and it may put some insurance out of the reach of many poor people who we want to be insured.
Good evening, everyone. Thanks so much for coming out and getting informed with all of us. I'm going to be dealing with Proposition 32 tonight. And Proposition 32, I know I spoke with some of my family members who are union members. They got pamphlets from the unions. There have been a lot of commercials, so I'm sure you've heard a little bit about it. But I want to give some background as to what a yes vote on Proposition 32 would mean and what a no vote would mean. So as a little background, California has the largest number of union employees in the nation at 2.4 million people. And in 2011, 17.1% of employed California residents were members of a union. In a union, often your union leaders will take a certain portion of your paycheck, will deduct some in order to contribute to union-related politics, political causes. So for campaigns or candidates who support union goals. So what does Proposition 32 do? Proposition 32 would create two new prohibitions on corporations, unions, and government contractors. First, those three groups would no longer be permitted to make those direct political contributions to candidates for office and candidate-controlled committees in state and local elections. Second, corporations, unions, and government contractors would no longer be able to use payroll deductions as a source of funding those contributions. So what would a yes vote do? A yes vote would make the restriction of the use of payroll deductions to unions, corporations, and government contractors. They would no longer be able to do that for all of those three groups. Employees would still be able to make voluntary contributions through their unions, but they would need written consent every year from their employees. Corporations and government contractors would be subject to this limitation, although these types of organizations don't tend to take those payroll deductions like unions do. What does a no vote do? A no vote leaves the law as it is now, allowing payroll deductions and allowing direct political contributions. What's the fiscal effect of this bill? The fiscal effect, according to the Legislative Analyst's Office, is that the Fair Political Practices Commission, which is tasked with enforcing campaign and lobbying law in the state of California, would likely have to increase their budget in order to enforce this new law. However, the Legislative Analyst's Office also says that much of this cost might be offset by the fact that the Fair Political Practices Commission would be collecting penalties as a result of violation of this law. The proponents argue, the main proponent being the Howard Jarvis Taxpayer Association, the proponents argue that limiting the sphere of influence that special interests have in politics is an important part of our society. It can help to prevent political corruption because the prohibition on these contributions limits the leverage that special interests have on our politicians, and politicians will no longer feel indebted to these special interests. Also, proponents argue that Proposition 32 helps protect the political rights of these union members, not forcing them to make contributions that they don't deem as fit. They instead would evaluate where they want their money to go, and if they wanted to give consent to their union, they could do so. But if they didn't, they wouldn't be forced to make these contributions. Opponents argue that Proposition 32 isn't as even-handed as it seems. As I mentioned before, corporations and government contractors don't tend to take these payroll deductions, meaning that the biggest effect will be on unions, and a disproportionate effect in that. Moreover, unions don't have the access to the funds that corporations and government contractors do, meaning that corporations and government contractors, largely unaffected, would still be able to make these contributions to public action committees, all of these forms of contributions, because they do it now. There would be no change necessary. Opponents also argue that this has been on the ballot before. In Proposition 226 in 1998 and Proposition 75 in 2005. They were very similar in effect, the main difference being the inclusion of corporations. With the inclusion of corporations, opponents argue, though, that this has little to no effect, as I mentioned before. So, since the effect of this proposition would be largely the same as those previous two propositions, voters have spoken, and voters do not want this. That's what opponents argue. And that concludes my presentation. Thank you.
Good evening, ladies and gentlemen. I promise you I'm the last one, so I appreciate everyone staying to the end. My name is Patrick Brady. I'm talking about Proposition 31, also known as the Government Performance and Accountability Act. Proposition 31 does what I've categorized into 6 things. It would require the state to switch from a 1-year budget cycle to a 2-year budget cycle. It would require a 3-day waiting period on all legislation prior to passage, meaning that when the legislature enacts a bill, and once they make the final amendments, they have to wait 3 days before they actually vote on the passage of that particular piece of legislation. Proposition 31 would also require that the legislature and the governor identify offsets for any kind of spending increases or tax cuts in order to maintain a balanced budget throughout the budget cycle. Fourth, Proposition 31 gives the governor increased authority to cut spending in a time of fiscal emergency without legislative approval. Fifth, Proposition 31 creates a system of performance-based oversight over all government programs. And finally, Proposition 31 would authorize the creation of voluntary community strategic action plans to further the goals established within Proposition 31. Since it is a rather lengthy proposition, I won't go into everything today, but I encourage you to read the summary where I go over everything that was everything that's discussed in Proposition 31. I'll just emphasize the performance oversight and the community strategic action plans, since the two of those are somewhat interrelated. The performance oversight provisions require that every budget enacted by the legislature and submitted by the governor as well promotes 3 purposes by furthering 4 different goals. The 3 purposes of any budget within the state, according to Proposition 31, would be achieving a prosperous economy, achieving a quality environment, and achieving community equity. The 4 goals are increasing employment, improving education, decreasing poverty, and improving health. Every budget submitted would have to contain a statement explaining how it conforms to that requirement. And furthermore, the budgets would have to establish outcome measures for every major expenditure and for the budget in general, as to how best it will go about furthering those purposes and goals that I just mentioned. The 2-year budget cycle requirement within Proposition 31 has sets it up so that there's 1 budget for every 2 years, and that budget's enacted in the first year of the legislative biennium. And therefore, a substantial portion of the second half of the second year in the legislative biennium is dedicated to program review and program effectiveness. And the legislature would be required to create a schedule whereby they review every program and every agency once every 5 years. The community strategic action plans are voluntary associations that are created by local governments, authorized to be created by local governments. No local government is required to participate in any community strategic action plan. What these are is they're created in order to further the goals and purposes and goals that I mentioned earlier. The two main benefits to joining a community strategic action plan are that that local governments participating in action plans can identify particularly burdensome pieces of state law and modify that state law according to their purposes within their jurisdictions, so long as that law is functionally equivalent to the state law, and the legislature can veto that legislation that modification within 60 days. Proposition 31 would also establish the Performance Accountability Trust Fund, which is funded by 0.035% of the sales tax. There's not going to be a tax increase. It's going to take 0.035% of the current sales tax and funnel that into this Performance Action Trust Fund. That fund is going to be transferred to local governments participating in action plans. This particular provision is estimated to create a transfer of $200 million annually from the state government to local governments. Other than that, the fiscal impact of the rest of the provisions is fairly difficult to forecast because so much of it depends on how future state leaders will handle their new authorities and will operate within their new boundaries. Finally, just a little bit on the support and the opposition. While the Republican Party supports Proposition 31 and the Democrats are opposed to it, there is a significant conservative opposition to Proposition 31 in that they're worried that the action plans will incentivize the transfer of state money from suburban areas to urban areas and will hence really limit the ability of suburban areas to grow. Furthermore, there's a concern that the offset provisions will prevent tax cuts even in a time of government surplus. The offset provisions also receive criticism from the other side of the aisle in that it prevents spending increases. They're worried that prevents spending increases for core services, again, even if there's a surplus. As far as how the offset requirement would work in the time of government surplus, that's a bit unclear from the initiative itself. There's also a concern that the action plans will allow local governments to impede state programs and state goals by transferring significant amounts of authority and resources. Finally, the provisions allowing increasing the governor's authority to unilaterally cut spending during a fiscal emergency is worrisome and unpredictable because it all depends on how future governors will decide to exercise their authority. In conclusion, Proposition 31 is a very lengthy proposition that enacts quite a few changes to how California will go about the process of governing in the future, and I welcome any questions you may have later. Thank you.
Okay, well, amazingly, we got through them all at exactly the end time. But if people do want to ask a few questions, I'm sure we can stick around. You can also ask the students questions individually. And a lot of answers are contained in the rather thick book that we have provided for you. The hope tonight was to give you a quick synopsis of each of the propositions. There's a lot to think about. The expectations on us as voters that we be informed are very high when we have this many initiatives. And when you hear about Proposition 31 and some of these others that are very complex initiatives with a lot of moving parts, it is incumbent on each of us to try to inform ourselves to the best of our abilities. So if anyone has a pressing question on one of the initiatives, we'll certainly take it. Yes, Erin. Yeah, the answer, I'm going to take it. Okay, so the question was, I'm just going to take it, sorry. So the question was, if both 38 and 30 pass, will the sales tax part of 30 go into effect? Because there's not a direct conflict between the increase in the sales tax and there is a direct conflict. The answer is it'll go to court, is the short answer. And the likelihood, though, is that because both 30 and 38 put into their initiatives, the drafters put into the initiative that they conflict, there's some evidence in the propositions themselves that they view themselves as conflicting measures. That is likely to influence a court. It may not be the final word on it, but you will have litigation. The likelihood is if 38 gets more votes than 30, the trigger cuts will happen, because 38 does not go directly into the general fund and is not what is contemplated by our current budget bill. So even if 38 passes, very likely it will be the case that, if 38 and 30 pass, but 38 with more votes, the sales tax will not go into effect and the trigger cuts will happen, is best guess, but again, likely to be litigated. Other questions? Yes.
I have a question on Proposition 37, and I understand what was said, but what I got out of the presentation was that there was going to be compliance and monitoring set up to see if these companies and food manufacturers comply. And I got no impression about where this money was going to come from to set up some sort of state agency to monitor compliance, considering how we have no money in the state as it is. How would that happen?
Yeah, I think that it does not say is the answer, right? So the Department of Health will be charged, California Department of Health will be charged with creating regulations and enforcing those regulations, but there is not a separate fund for it. Perhaps fines from the people who didn't label right will go into that pot, but it's not specifics, correct? Yes, okay. Sir?
Maybe in your book here somewhere on Prop 30, is there a projection on how much revenue it's supposed to result in overall?
It's supposed to result in about $6 billion a year, per year. So that $6 billion is already accounted for in the current budget, like already spent for this year, but not spent yet for next year. But it's supposed to be $6 billion, and both 38 and 30 have a sunset provision. So these are not indefinite. This is not forever. I think it's 7 and 4 for 30 and 12 years for 38. Whew. Okay. Eric.
Regarding Proposition 34, if they don't give the death penalty to just for having committed murder, what are the circumstances that actually allow for the death penalty?
Go ahead.
In California, currently there are 4 situations where you would be punished with the death penalty. One is treason against the state of California. The second is train wrecking resulting in death. So you don't have, murdered or killing doesn't have to be your objective, just purposely train wrecking that results in death, which is almost never used, as I'm sure you imagine. The third is murder with special circumstances. In those special circumstances, there's a long list, but a lot of them involve multiple murders, involve gang activity, involve rape. So there has to be not only first-degree murder, but it has to be heightened with a special circumstance to be death penalty eligible. And the fourth one escapes me right now, but it's in the packet.
Any other pressing questions? Okay, thank you all very much for coming.